contracts, and we'll get into Chapter 9, which will also talk about contract enforcement, etc. So, yeah, let me just want to make sure my little deal's working. There we go. Okay. So, contracts are it. I mean, we talk about a lot of things in business law, and we'll go through a lot of other chapters. And honestly, if there was one thing in terms of business law that you really could concentrate on, unless you're going to become a lawyer, would be dealing with contracts and how important they are in our day-to-day business and day-to-day lives, actually. So. That one's got, I'll let you guys read that. It's kind of a funny little story about a contract. And this one's kind of a funny cartoon, but it really points out something that's extremely important in contract law, too. It says it's a house made out of sand. What did you think I meant when I said I owned a beach house? And that's one of the big problems with contracts, even those that we think are really, really explicit, is that, words and language can be ambiguous. And so one person can put something in a contract, even not intending it to be ambiguous, but it can turn out to be that way, or it may be interpreted that way by the other person. And so when we see contract disputes, oftentimes it is about those ambiguities. So it's also extremely important to remember that 99.9% of the contracts, that get made and get signed or made orally, whatever the case may be, get fulfilled without any issue. It's probably even a higher percentage than that. Okay, but the ones we hear about, of course, are the ones that go awry, and so those are the ones we kind of study. And it seems that we probably spend an inordinate amount of time really talking about the ones that go awry, because the vast majority of them just happen as we expect them to. So anyhow, a contract involves promise, exchange of promises, right? To do something or to not do something. Could be either, right? It's important to note that contracts need not be in writing. There are some exceptions to that. There are some contracts that are required to be in writing. It can be a promise to perform or not to perform. Think not to perform. Probably the best example is a covenant not to compete, right, in a contract. I mean, you agree that you're not going to do something, and there's other contracts that you could have that would be like that. It has to be legally enforceable. And it definitely improves buyer-seller relationships. So contract law comes either from legislation. We've got the Uniform Commercial Code, and I bet you in law school they probably teach at least one full semester just on the UCC, or Uniform Commercial Code. What's important for you guys to know, because we're not going to get into all the nuances of it, is that it's a law that's been passed by all 50 states, okay, that makes the treatment of contracts and purchase of goods and those types of things consistent, both within states and across state lines. Okay, it makes it possible for us to, go to Washington and buy something and bring it home, basically. Okay, I know that seems mundane. It just seems like that's something we've always done. We just take it for granted, but without these laws in place that would allow those things from state to state, might be a lot more difficult. Okay, and we have legislation that covers contracts for goods, and then we have common law, judges' decisions that have been made throughout the years, and their relevance to contracts, and then contracts for other than goods or services. Really, I mean, this is probably contracts for goods and services, contracts for other than goods. And these are some oftentimes that have to be in writing. It might be, for example, a contract to pay the debts of others. Guarantee or co-sign a loan, right? Might fall into that category. And there are those types of contracts that are valid also, that kind of, they're outside of the normal parameters of contracts, and those normal parameters we'll talk about. So there are bilateral and unilateral. Know the difference, okay? Know the difference. Bilateral is... I'm sure we're going to talk about all these. So express, or the terms are discussed. Implied, in fact, okay, there's no discussion necessarily, but just implied. And then implied in law, neither discussion nor conduct, but one party unduly enriched. So a bilateral contract is a promise for a promise. This is by far the most common, bilateral versus unilateral. Okay, so right now we're just making the distinction between bilateral and unilateral, and that's important for you guys to, not confuse that as we go forward into express and whatnot. They're just kind of different facets of contract law. So bilateral is a promise for a promise. I'll buy your bike for $50, and Chuck says that, and Cindy says, fair enough, I'll sell you my bike for $50. Okay, they've both made a promise. Chuck to pay $50, Cindy to sell the bike. Boom, it's a contract. Each made a promise, and they would fulfill that promise. Okay, unilateral contract is a promise for performance. Okay, a promise for performance, and this is more like a reward. Okay, this is more like a reward. I promise you, I'll give the finder, the person that returns my dog, I'll give them $10. Okay, reward offered, right? Okay, that's a promise for performance there. Don't confuse that with like contracts that are for services, like maybe you contract with a contractor to build a house. Okay, that's still a bilateral. That's a promise for a promise. You're promising to pay money. They're promising to build your house. Okay, but this is a promise where the person that performs it may be unknown, right? So it may be unknown, and so it's a unilateral contract. It's just kind of throwing it out there, saying that I'll do this if somebody fulfills this promise or fulfills my request, I guess. So quite a bit more rare, but we see them. Certainly we see them, and they're certainly enforceable, right? So contract classifications, right? We can certainly have express, where the terms are discussed, maybe written, but not necessarily. An express contract can certainly be one that's unwritten, oral contract, that's fine. And then implied in fact, and we've kind of already talked about it. I think we still talk about those some more, maybe not. Maybe I better. I'm gonna go ahead here a little bit, make sure that we have that. Yeah, let's talk about that, and I guess if I get to it later. So an express contract, that one's pretty obvious. I don't need to talk about that a lot or give you any examples really, but these are every day too. We sometimes think of these as being real complicated, but they're not. It's going to the coffee shop and getting a cappuccino, mocha, frappuccino, latte, soy, light, something, grande, whatever, right? And that's on the board, and they want $4, and you pay them $4. Okay, technically that's an express contract, right? And implied in fact is conduct rather than discussion, and so this can just take I guess different scenarios. I'm going to pause for a minute here, sorry. Yeah, okay, sorry about that. I was having a brain fart and couldn't think of a good example of implied in fact, even though it's simple, but again, just a brain fart. But an implied in fact contract might be, example I looked up would be, your son contracts to mow, the neighbor's yard. It's an oral contract for the summer, right? And goes over every weekend and mows the lawn and gets paid on Monday. And about midway through the summer, your son goes over and mows the lawn, and the neighbor says, "Oh, I'm not going to pay you. I didn't want you to do it this week." Okay, the law would look at the conduct and say, God, he'd done it 4, 5, 6 weeks, been paid for it, even though there was no contract in writing or whatever. We're going to call that an implied in fact contract, and would require the person to pay your son or daughter, I should say, to mow the grass. Okay, implied in law, one party unduly enriched at the expense of others. There's probably decent number of examples of this. Maybe a lot of them that I've read, examples have been like doctor ones. Let's say you're in the hospital, right, and you're going in for a simple procedure, whatever it might be, okay, and they open you up and they find something else wrong, okay, and the doc says in the process of the surgery, well, geez, I guess we should take care of this other problem while we're in here. Okay, you certainly didn't have a contract, probably didn't, that authorized the doctor to do that. Okay, they might have some things in the contract that would, but let's assume they didn't, right? And so the doctor would be within his or her rights to charge you for that additional service, whatever it might be, and the court would impose that. Would say, hey, that was a reasonable thing. The doctor probably did you a favor because they didn't have to open you back up later and do it again. And so there's probably no question that the doctor would impose, or the courts would impose that contract upon the patient in that case. So enforcement. An enforceable contract is one where the court upholds the validity of it, right? Unenforceable says a party has a justifiable reason for non-compliance, and there's many, and we'll talk about, I think, some of those justifiable reasons as we go along. A valid contract is one that has all the essential requirements. A void contract is one that lacks the validity or enforceability. It can be said to be void, okay? Or where a party, voidable, I guess, party has a right to withdraw. So if a party, obviously, if they have the right to withdraw and do, the contract then is said to be void. So promises can be executed or executory, right? And an executed is both promises are performed. Okay, if it's in fact a bilateral contract. An executory is promises not yet performed. One party may perform their part of the contract, but the other party has not, and so we would call that still executory unless both promises are performed. And performance is important in more complicated transactions, and the book may differ a little bit from my definition there. I believe executed means that the promises have all been performed, and executory is one where any part of the contract has not yet been performed. So, and obviously, buying a cup of coffee is pretty simple, right? One promise for another, you get your coffee, you pay your $5, away you go, right? When you get into more complicated transactions like building a house or building an apartment complex or doing things like that, obviously those things get to be a lot more scary, I guess. Scary being the word with that gal there. Breach of contract. And I think we talk more about contractual performance in the next one, so I think I'm going to skim over this a little bit. But breach of contract, party doesn't perform, right? There's remedies. One of the things is the party has to attempt to mitigate damages. So if I contracted to sell you a load of firewood for $200 and you didn't pay me, okay, I might still have to try to sell that firewood, and if I only get $150 for it, and I had to pay for some additional advertising, so my net was $125, I could still come after you for the $75, but I couldn't come after you for the full $200 necessarily, unless I made an effort to mitigate those damages. Okay, always things that we've talked about, right? Negotiated settlements, arbitration. We can have damage awards either through the courts or through arbitration, right? Specific performance is something that's fairly often prescribed, where the court just says, hey, you've got to perform. Let's say it's the other way. I contracted with you to provide some firewood, and you didn't have any real good reason to not do that, but you just didn't bring me the firewood. The court might say you have to go get it. Okay, you have to do it. Rescission is a right to rescind, okay, your portion maybe of a contract. Restitution, right, we make somebody whole if they were harmed, okay. And again, I think we go over those later when we talk about contractual performance. So contract formation, we have to have these two things, right? We have to have an offer, and we have to have acceptance. And the mirror image rule says they have to agree, right? The mirror image rule, that one I'm sure is on the test. So it says that one has to be the mirror image of the other. The acceptance has to be the mirror image. If it's not, technically what we have then is a counter offer, right? And we might have an acceptance of the counteroffer then, okay? And that again, those things are real common if you're negotiating. You're dickering over the price of a vehicle. It might go back and forth, right, for a long time. Okay, there has to be capacity, right? And I think we'll talk about capacity a little bit later. And there has to be legal. The contract has to be for a legal purpose. Okay, you couldn't contract with somebody to haul, and not in the state of Montana, actually no place in the U.S. to haul marijuana, right? If I gave you $20, to bring back a quarter ounce of marijuana from Washington while you're over there where it's legal, okay, and you got caught, okay, or you didn't do it. I'm sorry, I gave you the $20, okay. Let's say I gave you the $20 to do it and you didn't bring back the marijuana. Okay, I could ask for my $20 back, but if you didn't give it to me, I'd have a tough time enforcing that, right? Because it wasn't a legal purpose. Okay, illegal to transport that stuff across state lines. Even though it might be sort of legal in those states, remember it's illegal nationally still by federal law. Okay, and supported by consideration. And consideration is a concept where each side has to suffer a legal detriment or give something up, right? Simple if we're talking about that cup of coffee. I'm giving up $5. The business, Starbucks or whatever, is giving up the coffee and the time and effort to go into making that, producing it, right? Okay. Sorry, I skipped over capacity a little bit here, and I didn't mean to, but capacity can mean a lot of things. It could be age. You have to be 18 to enter into legally binding, okay? Does that mean that if you're 16, you can't go buy a cup of coffee? No, of course you can. Okay. Again, that's just one of those things that we kind of accept as an exception to the rule. That and it probably deals with the necessities. You can go buy gas. You can go buy certain things like that. Could you enter into a contract to buy a car? Well, you can pay for the car if you pay cash for it. Yeah, that's fine because that's a simultaneous transaction. But if you had to borrow money, okay, then that would create a whole another scenario. Okay, for there to be an offer, there has to be intent. Okay, and this is we get into those types of arguments oftentimes with the states, right? So did the person who set up the estate, did they intend for that? I just finished a Grisham novel called Sycamore Row, and this is what it was all about. I mean, a whole novel, a 600-page novel or whatever it was about a dying man's intent or not intent to give his estate away, right? And pay lots of lawyers and those types of things to try to decide those things, and they're extremely difficult issues. And if you read, that's a good book, because if you read that, you understand what some of the issues are. Definiteness. Oh, say that fast 3 times. Okay, so it has to be definite, right? And there has to be a termination. Okay, or there should be. If there's not one noted, then there is a legal termination. Acceptance, right? If it's bilateral, it's a promise, and that's accepted. If it's unilateral, one of those reward things, then it's the performance. And the mirror image rule, we talked about that on the prior deal. Silence, and this says silence equal acceptance, but it should say silence cannot equal acceptance. Okay, silence cannot equal acceptance. Years and years ago, this is a long time ago, I remember reading about it. It was even before me. But credit card companies, when they first started coming out with credit card companies, well, they figured out that college graduates were good customers typically, and so they'd automatically send college graduates credit cards and just set up an account for them. Not unlike what Wells Fargo just got done doing, kind of. Except they'd actually set up the accounts and give them the credit card and give them a $5,000 limit. Back then it was probably a $500 limit, but they would do those things, right? And for a while that was considered okay, but that was a silence equaled acceptance types of things. And the courts came in and said, no, silence cannot equal acceptance, and so they did away with that. The deposited acceptance or mailbox rule, they're related, or basically the same thing. That if you put it in the mail, it's deemed to be accepted, basically at that point. Okay, Offers termination. There can be a provision in there, right? Here, I'll give you, 30 days to make up your mind, right? Here's my offer. I'll sell you my house for $100,000, and you got 10 days to decide, right? And so an offer would terminate if it went past that time frame, and that can be in the contract. It can be statutory too. And it probably differs. I guess I don't know, and it probably differs from state. It probably differs from types of contracts. But there's a just an offer, to pay somebody $20 for whatever reason can't exist forever. Okay, so if they perform it 100 years from now, it doesn't mean that your heirs and devisees and have to pay that, right? So there's statutory lapses of time. Rejection. So the offer's made on one side, it's rejected on the other side, it's terminated. Revocation. Okay, so I make the offer, and I haven't heard back from you yet. I can any time between then I can revoke the offer. Say, sorry, I changed my mind. That's okay. Destruction of the subject. So the offer is to buy the house, and you're just down in Florida there, mid part of Florida, coastal Florida, I should say, or South Carolina or Georgia, and the hurricane came across, and there was an offer in. Yeah, it'd be kind of tough, right? Offers death or insanity or infirmness, okay, as they get older and whatnot, possibly, and the performance becoming illegal. Okay, and so that can happen. That happened. In fact, one of my old customers, he had contracts to allow people to come and hunt elk, and they made that tame elk hunting illegal, basically, and as a result, those contracts that he had became revoked, I guess you would say, or terminated. So consideration, right? Something of legal value, something bargained for. So we each give up something, and again, keep it simple, right? That there has to be consideration in most contracts. Okay, the cup of coffee for $5 is a good example. It gets to be a little bit more complicated. When you get to like contracts to build apartment buildings or whatnot, and then what if you add in another part here while you're at it? Could you build this, but you don't agree on any additional payment? Okay, well then there's a lack of consideration in that case. Okay, and so that part of the contract, or that new contract, whatever you want to call it, might be considered void in that case. So consideration's important. There's also lots of exceptions to consideration. There are contracts that you can enter into, and again, it kind of goes back to that contracts for other than sale of goods and services, like again, guaranteeing a loan for somebody else. You get no consideration, right? Promissory estoppel, right? Okay, here we talk too. This is another case where consideration isn't necessary. Think again, and probably a good example here is about estates, right? So if I'm promising that when I die, my estate's going to go to a non-profit, maybe, right? Obviously the nonprofit doesn't have to give up any consideration, right? Okay, and promissory estoppel means that somebody trying to take my estate and send it someplace else would be stopped basically from doing that. Okay, and that it would in fact go to where I had put it in my will, that it would go, right? And so in this case, there doesn't have to be consideration. There is a reliance, that not-for-profit is relying on my promise, and if they don't receive it, there would be economic injury. And so that's what we talk about when we talk about a promissory estoppel. We get back to capacity. Okay, we are going to talk about that issue in contract, right? So lesson 18 now, they're necessaries. And again, simultaneous contracts happen all the time. Yeah, you go to McDonald's, you pay your $10, and get your Big Mac and fries and supersized soda. Okay, boom, right? Minors can, if they are allowed in some fashion to enter into a contract before they're 17, they can actually void that or disaffirm it when they get to be, I think it's 90 days after they turn 18. Okay. Now, if you entered into a contract, let's say you did borrow money to buy a car, okay, when you were 17, and somehow they let you do it, okay, and you got to be 18, you say, ooh, this is sweet, I'll just disaffirm this, or I'll disavow it, or I'll void it. You could do that, okay, but guess what? You don't get to keep the car. Okay, it means that the contract itself is void, and so each party kind of gets back their stuff. Now, if you ruin the car, which probably would be the case, then the bank or whoever that financed it is still going to suffer some major consequences for letting you do that, right? And they wouldn't be able to come after you for any deficiency in those cases. So, people that are intoxicated or under the influence may not be able to enter into contracts. Okay. People that are mentally incompetent. Again, we talk about people that are getting older and less firm in their mental abilities. In vino and wine there is truth. Yeah. Remember, being voluntarily, right, doesn't automatically make a contract void or voidable. So, how much, what the contract had to do with, what the other person's conduct was. I mean, if they knew you were drunk and they were taking advantage of you, that's different than if you were the one really pushing it and wanting to get into that type of a contract thing. So okay, later on we're gonna talk about trust and antitrust law and whatnot, and restraint of trade is one of those, and those types of things are illegal. So all the gas stations in have or can't go together, and this would be a price fixing, but it's a type of restraint of trade, and agree that they're going to sell gas for 10 cents higher. Okay. They just can't do that. Gambling to a certain extent. In Montana, we've got certain gambling laws. Usury laws. Up until recently, Montana didn't have a usury law, but we do now. And that sets an upper rate for interest that can be charged. Okay, and that's why all the payday loans and whatnot close down in Montana, because we ban usurious conduct. Okay. Unlicensed, right? People, somebody that sets himself out to be a plumber and comes and does work that he's not licensed for, he or she isn't, right? Might be illegal, right? Exculpatory, trying to relieve oneself from liability within the contract itself, and you see this, and people can sure put in statements, and they do, and they should, that skiing's a dangerous sport, and you have to accept a certain amount of the responsibility, and la da 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 da. And those end up in contracts. If you're going to go skiing, sometimes you're going to sign your ticket or something, or when they give you a ticket, it might say that on there, or there's big signs up that say those types of things. Okay, but that doesn't mean that the ski hill doesn't relieve them of the obligation to try to make the area safe. So, if you fall on a well-groomed slope that's in good shape and you get hurt, probably your fault, right? But if you hit something, an unmarked object that should have been marked, they're probably still going to hold the resort accountable. Okay, things that are unconscionable, just think about your own thing. It's hard to come up with great examples of that, but then things prohibited specifically by law. Covenant not to compete is perfectly fine. Okay, there's nothing wrong with covenants not to compete. I do think they have to have a certain time frame on them. So voidable contracts is if there was fraud or misrepresentation, and those are simple. Those are similar, right? Fraud's outright, misrepresentation is a little more subtle, I guess. Duress, there won't be anything on the test that would draw a distinction between those two. Duress, we understand duress, right? That here, sign this over to me. You see that in a lot of the old westerns, the old shows on Bonanza, or you guys aren't old enough to remember those, but yeah, they held my daddy and I had to sign this over, or else, that's duress, right? undue influence. And I saw some cases like this at the bank, and sad cases where, again, we were dealing with some older folks and some younger folks unduly influenced those folks to sign over money, give them money, do different things like that. Kind of sad, and that happens all too often. There's scam artists out there any place, right? Mistake, mutual or unilateral. Mutual mistakes are fine. That's going to avoid a contract if both sides kind of agree that, hey, we screwed up, we goofed this up, we got to redo it. That's fine. But a unilateral one, not necessarily. Okay, and again, that may be, based on the contract. If you had an oral contract and you just happen to write it down wrong, got in a hurry, and the courts might agree then that it could be voided. But on the other hand, if you just quoted them a wrong price because you didn't have your facts straight, maybe not. Okay, maybe not. And then mutual assent, contracts can be voided if both parties say, yeah, that's fine. Oral contracts, generally enforceable as written agreements. They're informal, every day, right? Just things we do, fast food, vending machines, those are all technically contractual things. Okay. Written contracts, and has to do with the statute of frauds, and okay. So all these are examples of contracts that do have to be in writing. We say that oral contracts are normally fine, right? But interest in land, interest in land needs to be in writing. So you sign deeds, those types of things. Certainly most easements and those types of things probably need to be in writing. I would say the part performance might be, neighbors, one neighbor saying to another neighbor, sure, you can drive across my property to get to your own, property. That's technically an easement, and that's probably what they're saying when it's part performance, right? They're saying that you can allow those types of things, and you may be contractually obligated, right? If you do that, and so might the person that comes behind you in terms of the land. But anyhow, pay debts of others or guarantee loans, right? 1 year plus for performance. So if we've got a contract, some of these baseball players and stuff, right? They're signing 5-10 year contracts, whatever it is, 5 or 6 or 7 year contracts. Baseball, football, basketball, hockey. Okay, those are going to be in writing, right? Sale of goods over $500, and again, I think in cases of simultaneous transactions, it doesn't necessarily have to be in writing. You don't have to sit down and write the contract out before you do that if it's a simultaneous contract. But if it's going to be some time, then it should be in writing. Okay. The parole evidence rule, probably going to be on the test. The parole evidence rule says that we're going to defer back to the written agreement. If people make claims about oral contracts or oral agreements that happened after the written agreement, we're going to go back to the written agreement and use that to make our decision. So, you buy a car from the XYZ dealership, and you get her all done, and you sign the deal, and and you say, oh yeah, you guys were going to put a seat covers in that car for me. Yeah, says the salesperson, of course. And you go to pick up the car, and it doesn't have seat covers on it, and you whine and moan. Okay, you might not get them, right? Okay, I mean the dealership may be nice and give them to you, but they wouldn't have to, right? Because it ended up being a verbal agreement that was after the written agreement had been signed, and so they defer to or look at just the written agreement. Exceptions to the statute of frauds, and we kind of already talked about that. Judicial admission. Wow, yeah, that won't be on the test. Not even sure what that is. Okay, so don't worry about that. Rules involving goods. Okay, UCC, specifically some manufactured goods and whatnot. Don't worry about exceptions to the statute of frauds. I don't think any of that's going to be on there. So, okay, we're getting into some pretty deep stuff there. So third-party rights. Third parties can be involved in contracts, intended or unforeseen. So Mary and Bob get divorced, and as a part of the divorce agreement, Mary agrees that she's going to pay for the kids' college education. Okay, well, the kids then become third parties, right? They're not signers of or anything like that, right? They can, they can certainly, they can certainly enforce those rights in that case, even though they didn't sign onto it or anything, right? Okay, and so they could become involved in that contract and have to enforce their rights and make Mary pay for their way through college if when they get to that age, and if she refuses to do so. You can have third-party beneficiaries. Again, think of making donations, doing some things like that, right? Donee. Trying to think of donee, it'd almost be a second party though, wouldn't it? But we call them a third party. Okay, they can be incidental to the contract. They can still enforce those rights like we talked about earlier with promissory estoppel. So interpretation, they'll use the trade language. Okay, we find right that a lot of different trades they really have their own language. There's people that talk computer, for example. I got no idea what they're talking about. It's a foreign language. Okay, and so we would interpret the contract as to their language, even if you had to bring somebody in to interpret it, right? You might have to. Okay, contract rights can be assigned oftentimes. Okay, you'll see that in maybe contract for sale of land or something, right? Where, in fact, you see that with big banks all the time. They finance you to buy a house, and then they package all those loans up and they sell them to another servicer. Okay, and they do things like that, right? And odds are the rights to transfer right in the original agreement that you might sign. But those can, those can extend even to private parties. Might do something like that. I might sell some land on a contract, and after a few years decide that I want to let somebody else worry about it, and so I could assign that, sell my rights to that to somebody else. Okay. Original party novations. I don't ask you any questions about novations, but original parties relieve the obliger from liability, and there can be a substitution made. That may be if somebody wants to step in on they're the ones making the payments and whatnot. Okay, and you agree to let somebody else substitute for that. It can happen. Again, I don't think that happens very often that we really need to worry about it. Okay, I think that should be about it. There we go. All right. A little longer. Contracts, like I say, is a long subject matter.